Jai Hind everyone. I am Dr. Akash Kumar from the Department of Applied Science and Humanities, and will be going through the subject topic of intellectual property rights and under the subject of Constitution of India, Law and Engineering. So, topic for the today's lecture is intellectual property right and related laws. Well, the discussion of the lecture will be moving according to the introduction. What is intellectual property rights? Procedure for the grant of a patent in India, pre-grant and post-grant opposition, right granted by a patent, infringement of patent, licensing and assignment of patent, copyright and ownership, meaning of copyright ownership, what is copyright infringement, understanding copyright infringement related issues, remedies for infringement of a copyright. Then we will also discuss the civil remedies which are available for copyright infringement, and finally would like to conclude the discussion by going through some kind of related conclusion. As far the introduction of the topic goes, the history of patent law in India starts from 1911, when the Indian Patent Act and Design Act 1911 was enacted. At present, Act 1970 came into force in the year 1972, amending and consolidating the existing law relating to patent in India. The Patents Act 1970 was again amended by Patent Amendment Act 2005, wherein the product patent was extended to all fields of technology, including food, drugs, chemicals and microorganism. Microorganism means some field of biology or botany. However, it must not fall into the category of inventions that are non-patentable as provided under section 3 and 4 of the Indian Patents Act 1970. In India, a patent application can be filed either alone or jointly by a true and first inventor or his assignee. The patent laws is that area of law that deals with an inventor's exclusive rights to use their own inventions. Exclusive right, that means sole right, he will be enjoying sole right over his invention. It is a right that empowers the patentee, that is the patent owner, to prevent or stop the use of his or her invention by third parties without his or her permission. So therefore, it basically try to give the ownership rights to the individual and confines any other person to use that particular patented. Patent includes right to license other for the purpose of making, using or selling the patented invention. It is a contract between an applicant or inventor and the government, wherein the government provides right of protection of the invention for a limited period of time after the full disclosure of the invention by the applicant or inventor. An invention relating to a product or a process which is new, involving inventive step and capable of industrial application can be patented in India. Intellectual property right is protected in law by, for example, patents, copyrights, trademarks, which enables people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interest of innovators and the wider public interests, the intellectual property system aims to foster an environment in which creativity and innovation can flourish. Ultimately, it leads to create such an environment, legal environment, where nobody can easily copy the invented or written documents, or invented any kind of activity, any kind of process, any kind of good or item, whether scientific or whether artistic, cannot be copied by the individual unless and until he gets the agreement with the patentee or the inventor. What is intellectual property? The intellectual property IP refers to the creation of mind, such as inventions, literary and artistic work, design and symbols, names and images used in commerce. The various types of intellectual property rights, we will just go through them. The copyright number 1, patents number 2, trademarks number 3, industrial design number 4, geographical indications, and the trade secrets. All these come under the category of intellectual property right, because they conserve the right of the holder that being copied or being snatched away by some other person. Copyright. It is a legal term used to describe the rights that creators have over their literary and artistic work. Works covered by copyright range from books, music, painting, sculpture and films, to computer program, databases, advertisement, maps and technical drawings. Basically all these things come under the category of the Copyright Act. Patents is an exclusive right granted for an invention. Generally speaking, a patent provides the patent owner with the rights to decide how or whether the invention can be used by others. In exchange for this right, the patent owner makes technical information about the invention publicly available in the published patent document. The third category is the trademark. A trademark is a sign which is capable of distinguishing the goods or services of one enterprise or organization, we can say, from those of the other enterprise. The trademark dates back to ancient times, when artisans used to put their signature or mark on their product. Therefore, it distinguishes between a product being produced by a number of firms, such as we have different trademarks when we go for the brand. It ultimately also enhances the brand reputation or the goodwill of that particular brand in the eyes of the beholder or in the eyes of the user of that particular brand. Individual designs and industrial design, the industrial design constitutes the ornamental ethnic aspects of an article. A design may consist of three-dimensional features such as the shape or surface of an article, or two-dimensional features such as pattern, lines or colors. These are also come under the intellectual property. Geographical indicators. Geographical indicators and appellations of origins are signs used on goods that have a specific geographical origin and possesses qualities, a reputation or characteristics that are essentially attributable to that place of origin. The most commonly, a geographical indication includes the name of place of that good. Trade secrets. Trade secrets are intellectual property rights on confidential information which may be sold or licensed. The unorganized acquisition, use or disclosure of such secret information in a manner contrary to honest commercial practices by other is regarded as an unfair practice and a violation of the trade protection. That is, some business have some business secrets, and those business secrets let's say give a upper hand to the producer, that it differentiate between the same commodity be produced by the other firm, and of the same category, but due to taste, due to its ingredient, there is a particular goodwill that is attached to that particular brand, and that becomes the trade secret of that individual product. Patent of biological material. If an invention uses a biological material which is new, it is essential to deposit the same in the International Depository Authority prior to the filing of the application in India in order to supplement the description. If such biological material are already known, in such case it is not essential to deposit the same, but the IDA, that is the International Depository Authority in India, located at Chandigarh, is known as the Institute of Microbial Technology. Procedure for grant of a patent in India. After filing the application of the grant of patent, a request for examination is required to be made for examination of that application in the Indian Patent Office within 48 months from the date of priority of the application or from the date of filing the application. After the first examination report is issued, the applicant is given an opportunity to meet the objections raised in the report. The applicant has to comply with the requirements within 6 months from the issuance of the first examination report, which may be extended for further 3 months on the request of the applicant. After the removal of objections and compliance of the requirement, the patent is granted and notified in the Patent Office Journal. The process of the grant of the patent in India can also be understood from the given flowchart. As we go through this flowchart, we have the number of 5 steps: the patent search, filing patent registration application, preparation of patentability report, that is whether the patent file can be patented or not, review of application, any kind of review that has to be checked thoroughly, the application and the other related legal aspect will be thoroughly reviewed, and then issuance of the patent and registration certificate will also be issued at the step number 5. So therefore, this flowchart gives a precise idea that what are the various steps basically followed, where before any kind of invention becomes a patent, any kinds of invention becomes patent or a copyright. Pre-grant and post-grant opposition. The pre-grant opposition gives third parties the opportunity to oppose the grant of a patent just after publication of the patent application. A party need not wait until the grant itself. The post-grant opposition can be filed only after the grant of patent, but within 1 year of the date of grant. The grounds for filing pre-grant and post-grant opposition are discussed below. Some of the ground for filing pre and post-grant opposition are as under: number 1, patent wrongfully obtained prior publication. Invention was publicly known or publicly used in India before the priority date that claim. Number D, the invention is obvious and does not involve any inventive steps. Number E, that the subject of any claim is not an invention within the meaning of this act or is not patentable under this act. Next, insufficient disclosure of the invention or the method by which it is to be performed. Next, that in case of a patent granted on convention application, the application for patent was not made within 12 months from the date of first application for protection of the invention made in convention country or in India. That the complete specification does not disclose or wrongly mentions the source and geographical origin of biological material used for the invention, and finally that the invention was anticipated having regard to the knowledge, oral or otherwise, available within any local or indigenous community in India or elsewhere. The term of patent, it's most important to understand. The term of every patent in India is 20 years from the date of filing the patent application, irrespective of whether it is filed with provisional or complete specification. However, in case of application filed under the Patent Cooperative Treaty, that is PCT, the term of 20 years begins from the international filing date. The payment of renewals or renewal fee. It is important to note that a patentee has to renew the patent every year by paying the renewal fee, which can be paid every year or in lump sum. Restoration of patent. A request for restoration of patent can be filed within 18 months from the date of cessation of patent along with the prescribed fee. After the receipt of the request, the matter is notified in the official journal for further processing of the request. The rights granted by a patent. If the grant of the patent is for a product, then the patentee has a right to prevent others for making, using, offering for sale, selling or importing the patented product in India. If the patent is for a process, then the patentee has the right to prevent others from using the process, using the product directly obtained by the process, offering for sale, selling or importing the product in India directly obtained by the process. Before filing an application for a grant of patent in India, it is important to note what is not patentable in India. Any invention which is frivolous, obvious, contrary to well established natural law, contrary to the existing law, morality, injurious to public health, a mere discovery of a scientific principle, and the formulation of the abstract theory, a mere discovery of any new property or new use for a known substance or process, machine or apparatus, a substance obtained by mere admixture resulting only in the aggregation of the properties of the component thereof, or a process for producing such substance, a mere arrangement or rearrangement or duplication of the known device, a method of agriculture or horticulture, and finally, the inventions related to atomic energy are not patentable in India. So, we have gone through what are the patentable, what can be patented in India. So, these were some of the aspects under which the patent cannot be held, granted by the patenting authority in India. Infringement of patent. The patent infringement proceedings can only be initiated by grant of patent in India, but may include a claim respectively from the date of publication of that application for the grant of the patent. The infringement of a patent consists of unauthorized making, that is unallowed, which is not allowed and which is illegal, making, importing, using, offering for sale or selling any patented invention within India. Under the Indian Patent Act 1970, only a civil action can be taken or initiated in the court of law. Further, a suit for infringement can be defended on various grounds, including the grounds on which a patent cannot be granted in India. On such defense, revocation of patent can also be claimed. So, by infringement of patent, we basically means that anybody who claims that this patent has been already done by me, or he is stealing some kind of stealing some kind of knowledge of the existing patent, then that particular patent can be said to be the concept of infringement. It basically the illegal aspect, unauthorized dealing act which is not supported by the court of law. Licensing and assignment of patent. An assignment in a patent or a share in the patent or a mortgage, license or the creation of any other interest in a patent is permissible. In case of patent, assignment is valid only when it is in writing and the agreement is reduced to form of a document embodying all the terms and conditions governing the rights and obligations of the parties to the agreement. The application for registration is required to be made by the transferee in prescribed form. Copyright and ownership. According to Section 17 of Copyrights Act 1957, the first owner of the copyright is defined as under. The subject to the provisions of this act, the author of the work shall be the owner of the copyright therein. Section 17 statutorily recognizes the author of the work to be first owner of the copyright. The author is defined under the Act for various works which come under the law of copyrights. Meaning of copyright ownership. There are three basic requirements that a work must meet to be protected by copyright. The work must be original, the work must be creative, the work must have some fixed requirement. Let's discuss these 3 points separately. The original, to be original, a work must merely be independently created. In other words, it cannot be copied from something else. There is no requirement that the work be novel, as in patent law, unique, imaginative or inventive. Creative. To satisfy the creativity requirement, a work need only demonstrate a small amount of creativity. Very few creation fails to satisfy this requirement. Fixed. To meet the fixation requirement, a work must be fixed in a tangible medium of expression. Protection attaches automatically to an eligible work the moment the work is fixed. The work is considered to be fixed as long as it's sufficiently permanent or stable to permit it to be perceived, reproduced or otherwise communicated for a period of more than transitory duration. So these are basic three aspects, three basic requirements which give precise meaning to the copyright ownership, and basically it deals with the originality of the work. It should be creativity, it should have some creative work has been done or written. The fixed, it must be according to the fixed as the protection is attached. It has to be fully meeting the requirement of fixation of work. Exclusive legal right that protect works to protect work of authorship, composition or artistry. A copyright protects the publication, production or sale of the rights to a literary, dramatic, musical or artistic work or computer program or the use of commercial print or label. What is the importance of copyright? Let's go into some understanding about this concept. It gives exclusive right to the owner of the original work to reproduce, duplicate, transcribe, and translate the work. The owner can prevent the misuse of the original work and can take legal action if infringement takes place. This is most important one in order to avoid and control the duplicacy of the literary work. The owner has the sole right to get monetary benefits from their work. And lastly, It encourages the society for creativity as the owners enjoy the benefits and protection of their creative work. So, these were some importance of the concept of copyright. What is copyright infringement? Let's go into detail. A copyright infringement is the use or production of copyright protected material without the permission of the copyright holder. The copyright infringement means that the right afforded to the copyright holder, such as the exclusive use of a work for a set period of time, are being breached by a third party. The music and movies are two most well-known forms of entertainment that suffer from the significant amounts of copyright infringement. The infringement cases may lead to contingent liability, which are amounts set aside in case of possible lawsuit. Understanding the copyright infringement, the individuals and companies who develop new work and register for copyright protection do so in order to ensure that they can profit from their efforts. Other parties may be granted permission to the use those work through licensing arrangement or may purchase the work from the copyright holder. However, several factors may lead other parties to engage in copyright infringement. Reasons include a high price for the authorized work or a lack of access to a supply of authorized work. Now, copyright infringement issues, let's have a look to this topic. The copyright infringement issues have varied over the years, but with rapid advances in technology, the Copyright Office has faced a growing number of issues in an effort to keep pace with the innovation. The important point here is to be noted, with the rapid advances in technology is one of the factor which has led to breach the copyright procedures. It has increased the cases of infringement of copyrights manifold. Number one is technology. Modern technology makes it relatively easy to copy a product or information, and some companies derive a substantial part of their revenue from replicating what other companies have created. In response, the Copyright Office establishes the Copyright Modernization Office in 2018. The division is responsible for coordinating IT, that is Internet technology, modernization projects with the goal of modernizing the Copyright Office as well as the Library of Congress. The international issues. The copyright infringement and the resulting law surrounding protection can vary from country to country with different options for recourse and different amounts of protection. In an international setting, it can be difficult to prove copyright ownership, and domestic courts may see enforcement of copyright claims from international companies as a threat to national productivity. Some international organizations such as European Union attempt to keep the regulations and enforcement guidelines of its member countries as harmonized as possible. Photography and visual assets. With the advances in the digital imagery, it's become easier than ever to copy an image. Over the past few years, the Copyright Office has been made aware of various copyright issues from photographers, illustrators, and graphic artists. Non-economic rights. Not all copyright infringement results in a measurable monetary loss per se. Moral rights are enforced as well, which cover an author's right to be identified as the author of a work, called the right of attribution. Also, authors look to prevent changes or distortions of their work called the right of integrity. The internet, the fifth point, the growing importance of the internet has created new obstacles for copyright holders. It is easier than ever for copyrighted material to be accessed by the companies around the world, and the creation of new technologies has outpaced the regulatory environment's ability to ensure that copyrights apply to new formats. So basically, the most important crux, the most important problem, or we can say the tool is the technology. The updation of technology is now become one of the major source of increasing the number of copyright infringement cases, and we have just discussed this concept. Some examples of copyright infringement include downloading movies and music without proper payment for use, recording movies in a theater, using others' photograph for a blog without permission, copying software code with giving proper credit, without giving proper credit, creating videos with unlicensed music clips, copying books, blogs, or podcasts without permission, anything where you are copying someone else's original work without an agreement. So these are some of the examples. We have just gone through the concept. What are the remedies available? Number one, the civil remedy as far as the topic goes. According to section 55 of the Copyright Act 1957, where copyrights in any work has been infringed upon, the owner of the copyright shall be entitled to all such remedies by way of injunction, damages, and accounts. Accounts here means money related aspect. Criminal remedy is according to section 63 of the Copyright Act 1957, the copyright holder can take criminal proceeding against the infringer in which there is a provision of at least 6 months imprisonment, which may be extended up to 3 years, and with a fine of rupees 50,000, which may extend to rupees 2 lakhs. Civil remedies available for copyright infringement. Section 55, civil remedies for infringement of copyright. Subsection 1 of the section 55 talks about the various forms of remedies which are available, and it says that when a copyright of any work has been infringed, the owner of the copyright shall accept as otherwise provided by the provisions of the Indian Copyright Act 1957, be entitled to all such remedies by way of injunction, probatory orders, which are damages, accounts, and otherwise are or may be conferred by law for infringement of a right. A provision has been added to this clause that if the defendant proves that the date of the infringement he was not aware and had no reasonable ground for believing that copyright subsisted in the work, the plaintiff shall not be entitled to any remedy other than an injunction in respect of the infringement and a decree from the whole or part of the profits made by the defendant by the sale of the infringing copies, as the count may in the circumstances deem reasonable. This concept gets its origin from the basic principles of law that no innocent party should be unnecessarily punished more than what she or he is liable for. Subsection 2 of section 55 says that in case of a literary, dramatic, musical, or artistic work, a name purporting to be that of the author or publisher, as the case may be, appears on copies of the work published, or in the case of an artistic work, appears on the work when it was made, the person whose name was so appears or appeared shall in any proceeding in respect of infringement of the copyright in such work be presumed unless the contrary is proved to be the author or the publisher of the work, as the case may be. As civil laws are used in proceeding of copyright infringement, so this presumption gets its origin from the provisions of Section 4 of the Indian Evidence Act. The subsection 3 of Section 55 of the Indian Copyright Act 1957 provides for the cost and the amount raised as claim as relief in matter of copyright infringement are generally very huge figures. So, cost of all parties in any proceedings in respect of infringement of copy is the discretion of the court. Interlocutory, or that is meeting injunctions, is the main civil remedy which is awarded in disputes related to copyright infringement. An interlocutory injunction is a court order to compel or prevent a party from doing certain acts pending the final determination of the case. It is an order made at an interim stage during the trial of the case and is usually issued to maintain the status quo until the judgment can be made. Finally, we conclude the topic. The Indian copyright law still is not fully developed and is still developing, just like our nation. It keeps on changing from time to time. What may not be a copyright today may be a matter that is copyrightable in near future. But still the Indian copyright law is sufficient statute to decide and govern matters of copyright disputes. It has a lot of remedies available in the case when a copyright is infringed, because protection of copyright is a big issue in modern world. It also provides a lot of defenses to that no innocent party is punished. The Indian Copyright Act has been amended for 6 times, latest being amendment in 2012. Many of these amendments have been done to comply with the TRIPS agreement, because India is a part of it, which makes the copyright law more updated and in accordance with changing scenario across the world. Still, there is a lot of grey matter regarding many concepts under Indian copyright law, and this needs some more development. Thank you all.